You can obtain the right to live and work in the United States without time limitations as a result of sponsorship by an immediate relative who is either a permanent resident or a U.S. citizen. A permanent resident can sponsor a spouse, children, and parents. A U.S. citizen can sponsor a spouse, children, parents, brothers, and sisters. An American citizen may sponsor a spouse or parents for a green card without regard to family preference. A spouse or parents being an immediate relative is not subject to numerical limitations of any kind. Under these conditions, a green card is usually issued to the immigrant spouse or parents in 6 to 12 months. But the spouse of a permanent resident that is a green card holder must wait about 2 to 3 years for a green card. In the later case, the spouse is classified under the second preference category, which is subject to annual numerical limitations. Because of the Marriage Fraud Amendment enacted under the 1986 Immigration Reform and Control Act, it is now harder to obtain a green card even for the spouse of a citizen or green card holder. The reason for these amendments was to halt the practice of marrying solely for green card purposes. Now, if a marriage is less than 2 years old, when the citizen immigrant spouse attend the Immigration and Naturalization Service interview, the immigrant spouse receives a conditional green card which is valid for 2 years. At the second interview, both parties go to the office of the Immigration and Naturalization Service for a final interview where they must prove that the marriage is genuine, not entered into for the purpose of acquiring a green card. If the interviewing officer is satisfied that this is the case, the immigrant spouse receives a permanent green card and the right to permanent residency. There are now 4 preference categories that allow for those with close enough family ties to immigrate to the United States. In the first preference category, F1, unmarried sons and daughters of U.S. citizens, 23,400 plus any numbers not required for fourth preference. In the second preference category, spouses and children and unmarried sons and daughters of permanent residents, 114,200 plus the number, if any, by which the worldwide family preference levels exceed 226,000 plus any unused first preference numbers. Second preference, F2A, spouses and children of permanent residents, 77% of the overall second preference limitation, of which 75% are exempt from the per country limit. Second preference, F2B, unmarried sons and daughters, 21 years of age or older, of permanent residents, 23% of the overall second preference limitation. In the third preference category, F3, married sons and daughters of U.S. citizens, 23,400 plus any numbers not required by first and second preferences. In the fourth preference category, F4, brothers and sisters of adult U.S. citizens, 65,000 plus any numbers not required by the first 3 preferences. In summary, family relationships of varying kinds, such as between alien, non-U.S. nationals and U.S. citizens or permanent residents, are the most important basis on which the overwhelming majority of immigration visas are sought and granted every year. For more information, call us at 718-625-0800 to schedule a free consultation.